Thank you for coming, everybody. I was telling Phil the last time I gave this talk, this is a relatively new talk for me, was in November. And one of the partners at Smith Gambrell was in charge of putting together the program. And it's a program that ICLE has every year, and people who go to it get a full year's worth of credit. And it's called Urgent Legal Matters at Sea. It is, in fact, a cruise, which I almost didn't go. I said, can I just give my talk and then get off the boat? And she's like, no. So I went anyway, and the venue was in a disco, the ship's disco with like the, ball thing that makes all the wild. And so to go from a bar with a disco ball to this beautiful worship space is pretty mind-blowing. But this is a topic that there seems to be an insatiable demand for speakers on this topic. And I have given this talk from sea to shining sea over the last 2 years. And most of the audiences that I present to really have no idea just how vast elder financial abuse is in our society. And it's called the crime of the 21st century. And it seriously seems to be getting worse every year. I'm afraid my materials were largely responsible for the 207 page count. And what I really hope they do is make a nice addition to your research file on elder financial abuse. There's the outline, and then there's this massive appendix that my librarian at the firm helped me put together. That for those of you who have clients in more than just one state, there's some helpful statutory citations for all 50 states, actually. So this is a topic that you read a lot about, too. I mean, everything from scholarly law reviews to last fall, the Costco Connection magazine, I don't know how many of you are members of Costco, had an article on elder financial abuse, too. And so over the last 32 years of my career, there have been several significant developments that kind of dovetail with this talk. Most of my clients have gotten older. More of my older clients have developed diminished capacity and become a lot more vulnerable to elder financial abuse. And sadly, more of the tried and true disability planning documents that I have prepared for my clients are being used against them by their trusted fiduciaries. And it's been shocking to me that powers of attorney that I've drafted, for example, have been used as a tool of elder financial abuse. And this phenomenon is being played out in law offices across the country, from lawyers that represent the rich and famous, like Mickey Rooney and Brooke Astor, who are two of the most high-profile victims of elder financial abuse, to my little pro bono little old lady client that I represented for 32 years before she passed away. And I dare say your clients have been subjected to this as well. And it's not just our clients. When I give these talks, I have people come up to me afterward and say that their own family members have been victimized by elder financial abuse. So if it hasn't happened to your clients and it hasn't happened in your own family, it will. So this is a topic that you need to hear about, and I'm really glad that you came this morning. So we won't be able to cover all of the information in the 100 pages of my materials, which I'm sure you're very pleased to hear. But if you printed it out or if you have it on your link, I'm going to sort of track in order. And so if you want to follow along, and from time to time I'll tell you where I am in the outline. But if you want to just sit back, relax, and enjoy the program, then you can do that as well. So let's start with a quick overview of the scope of elder financial abuse. There was a MetLife study produced in 2011 that estimated that the financial losses from elder financial abuse were $2.9 billion a year. And then 4 years later, last year, 2015, TrueLink Financial came out with an updated study estimating elder financial abuse at $36 billion a year. It's just staggering. So there's no generally accepted age at which a person becomes an elder. AARP, of course, is open to people who are 50 years and older, which would include most of us, not this young lady at the front table, though. The CDC defines elders as 60 or older. The Office of Older Americans of the Consumer Financial Protection Bureau is dedicated to those who are 62 and older. Georgia's statutes define elders as those 65 and older. So using this definition, the 2010 census recorded the greatest number and proportion of people 65 and older, 40 million people, representing 13% of the total population of our country. And by 2050, people 65 and older will comprise 20% of the U.S. population. And so, in addition to elders, however we define that, people with disabilities are also more susceptible to financial abuse and exploitation. 30% of people with disabilities report being abused at the hands of their caregivers. The most common types of elder financial abuse, the TrueLink study says that $17 billion each year is attributed to exploitation that is just within the bounds of the law, that uses pressure tactics and misleading language so that seniors make financial mistakes voluntarily. They're hoodwinked. $12 billion annually is attributed to criminal fraud, and that includes all the scams that we hear about, the grandparent scams, fake lotteries, sweetheart scams, along with outright identity theft. Another $6.5 billion annually involves abuse by people who are in a position of trust with respect to the elder, and that includes the improper or illegal use of powers of attorney. The Georgia Code defines financial exploitation as the illegal or improper use of a disabled adult or elder person or that person's resources through undue influence, coercion, harassment, duress, deception, false representation, false pretense, or other similar means for another's profit or advantage. And your outline sets forth numerous other state and federal definitions of elder financial abuse on pages 4 through 6. So who are the perpetrators of elder financial abuse? A majority, 51%, are strangers to the elder. And it is posited that stranger elder abuse is much more likely to be reported than the 34% of perpetrators that are known to the elder. And that would include family, friends, neighbors, caregivers, legal guardians, and representative payee under the Social Security Administration. And this category of elder financial abuse is significantly underreported, mostly because people are just mortified and embarrassed that people that they know and love and trust have ripped them off. 12% of elder financial abuse is perpetrated by business and professional service providers, including attorneys, along with bankers and financial advisors. Another 4% of elder financial abuse is attributable to Medicare and Medicaid fraud. And this category actually represents almost 60% of the losses, even though the number is smaller. And then finally, of the perpetrators of elder financial abuse, 60% are male. Who are the victims of elder financial abuse? The 2015 TrueLink study estimates that almost 37% of seniors have been victimized by elder financial abuse in the 5-year period that they were studying. And other studies have shown that women are more than twice as likely as men to be the victims of elder financial abuse. What are some of the most commonly cited reasons for elder financial abuse? The number one reason is that Alzheimer's disease and dementia increase with age. And that is the primary reason why so many of our elders are susceptible to elder financial abuse. 1 in 9 people over the age of 65 are affected by Alzheimer's disease or another form of dementia. 50% of people over 85 years of age have some form of dementia. And according to the Alzheimer's Association website, in the next decade, the incidence of Alzheimer's disease in the southern region is expected to increase by 45%. The brain changes that are associated with Alzheimer's disease begin 20 or more years before the memory impairment symptoms are apparent. And once diagnosed with Alzheimer's disease, only 45% of patients and 45% of caregivers are actually told of the diagnosis. So this results in decades of slow decline in financial capacity that can be taken advantage of by ne'er-do-wells. The second reason for the increase in elder financial abuse is documented neurobiological change in the brains of elders. There's an area of the brain known as the anterior insula that changes with age, and this adversely affects a person's kind of gut feelings about the trustworthiness of people. And so older people don't have those gut feelings that tell them to beware of someone as much as a younger person would. And there is another area of the brain called the orbitofrontal cortex that diminishes with age, and it causes seniors to take more risks than they should, especially in the financial arena. So the last reason that I'll mention is that elders today are largely socially isolated. It is very rare to find any more extended families with multiple generations living under the same roof, or even in the same town for that reason. And there are fewer people in the elder's life that are around to be able to detect that elder abuse is underway. So let's talk just for a minute about the detection of elder financial abuse. On pages 8 to 10 of the outline, there's a long list of what we call indicators or markers of elder financial abuse, any one of which might be attributable to some other cause, but patterns or clusters of these markers can reveal an elder abuse problem. Some are pretty obvious, and some are not so obvious. So I invite you to look those over when you get back to your offices. And so the troubling thing is that many of these markers or indicators of elder financial abuse can be detected only by monitoring almost on a daily basis the elder's financial affairs. And we as attorneys are just not in a position to do that for our clients. So let's talk about the reporting of elder financial abuse. The reporting is dismal, to say the least. An overwhelming number of cases of elder financial abuse go undetected, unreported, and untreated every year. One study says that only 1 in every 24 cases of elder financial abuse is referred to appropriate authorities. And the number one most cited reason for underreporting of elder financial abuse is that the victims themselves refuse to report it. The victim doesn't want the perpetrator, which is often a family member, to go to jail, surprisingly. The victim sometimes feels partially responsible for what has happened. She feels that admitting vulnerability will result in a nursing home placement for her own protection. And then, of course, the victim might not even recall the elder financial abuse because of dementia or Alzheimer's disease. So who are mandatory reporters of suspected elder financial abuse in Georgia? Almost all healthcare workers and people that are required to report child abuse are mandatory reporters. Any employee of a financial institution. And as of just last year, last July 2015, investment companies are now on the mandatory reporter list, and that includes brokers and financial planners. Attorneys are notably absent from the mandatory reporter list. And a recent study that was co-sponsored by the American Bar Association, the Investor Protection Trust, and the Investor Protection Institute concluded that 35% of attorneys are aware that they are dealing or may be dealing with a victim of elder investment fraud and financial exploitation. And yet, because they are not mandatory reporters, they don't report. The penalty in Georgia for failure of a mandatory reporter to make a report is a misdemeanor. And I've listed the code section in your materials. So when you suspect elder financial abuse, who do you call? So Adult Protective Services is the first responder mechanism outside of a long-term care scenario. And the state long-term care ombudsman handles elder financial abuse allegations in a long-term care setting. And in your appendix to your materials, I mentioned the 50-state survey. That includes statutory citations to the APS and the long-term care ombudsman in every state. And it also has contact information for something called the Elder Care Locator, which has a toll-free number and also an online presence, which is wonderful. I've used that in a number of matters that I'm working on. Yes?
Quick question. In my practice, we have care coordinators who are social workers, who are mandatory reporters under the child abuse. Would they be mandatory reporters because they're working for a lawyer? Not that I don't want to report. Don't get me wrong. I just want to make sure I know. Are they?
So the question was, for those of you whose practices include a staff member that would otherwise be on the mandatory reporter list, does the fact that that person is working for a lawyer somehow get them out of being a mandatory reporter? And I believe I would err on the side of sticking with the mandatory reporting. Whether the lawyer does anything with the information is another question, but I think the social worker or other person who is officially on the list it would behoove her to go ahead and fulfill that obligation. Good question. So how many of you have actually tried to initiate an APS or a long-term care? Not that many, and I am told by people who have tried to do it that it's actually not that easy, and that oftentimes nothing comes of it. And so the materials go through a long, long discourse on actually how reporting an allegation of suspected elder financial abuse unfolds in both long-term care and non-long-term care situations. There's a number of other resources, too, if you're just going to give up on the APS and long-term care ombudsman. There's a number of legal aid programs. There's senior legal hotlines. There's a number of private law firms that have a pro bono project. The Mickey Rooney Elder Abuse Pro Bono Project is around the country, and I think actually Holland and Knight is the one who sort of behind that, and the Atlanta office of Holland and Knight is doing that as well. And Georgia State University, the law school's investor advocacy clinic will help victims whose losses are $100,000 or less. So what are the remedies for elder financial abuse? Georgia actually has a specific criminal statute, and the site is in your materials. It's actually a felony under Georgia law, punishable by imprisonment of up to 20 years, a fine of up to $50,000, or both. However, unless the loss to the victim is very large, prosecutors aren't taking these cases. There was an article in the Atlanta Journal-Constitution a couple years ago where Sally Yates, who's the former U.S. attorney for Georgia, was quoted as saying that unless the victim had lost $1 million or more, they weren't interested in prosecuting it. And of course, the reasons for this attitude, very underfunded budgets, the effect of the victim's incapacity or memory issues on the ability to marshal the necessary evidence, and again, the victim's refusal to report it and cooperate with the prosecution of it, all combined to make it very unlikely that the statutes will be invoked. Georgia also has numerous civil statutes to redress elder financial abuse, including those that are specifically aimed at fraud, breach of fiduciary duty, rescission of abusive transactions, and an action for conversion of stolen assets. The state of Georgia in the last several years has actually done something pretty cool. They've put together something called the At-Risk Adult Crime Tactics Specialist Program, ACT. And this is a multidisciplinary team from across all disciplines that are specifically trained to go and ferret out elder abuse, neglect, and exploitation. And it was either last year or the year before, Georgia Public Broadcasting did a documentary on this called Elder Abuse Hiding in Plain Sight. Did anybody happen to see that? The link is referenced in your materials, and it's a real eye-opener, and I would heartily recommend it to you. So even for those that are prosecuted, most of these perpetrators are judgment-proofed. The assets have already been dissipated. There's probably a reason why they're stealing from old people. They don't have a lot of assets. And so even in cases where there is a prosecution, the guy may go to jail, but there's very little recovery for the victim. And then increasingly, it is hard to find private attorneys that are willing to take on these cases. I mean, I'm on the same listservs you guys are, and at least a couple, 3 times a week, there's a email sent out saying, who takes these cases? Who can help people get their rights restored or their property restored? And there aren't a lot of private attorneys that are willing to take on these cases. There are a number of probate court remedies for elder financial abuse, and one of them, of course, is the appointment of a conservator as a protective, defensive measure, and David is going to be talking about guardianship and conservatorship later today. But sadly, we are seeing the conservatorship process, instead of being used as a protective, defensive measure, being used in an attack mode where the elders are wrongfully deprived of the ability to control their assets as they see fit. And the classic example is, the dysfunctional family. Are there any other types? Where one child is kind of on the outs and the elder parent is making annual gifts to the good children. The bad child is hacked off about this, files for a guardianship and conservatorship on dad so that he can prevent dad from giving assets to these other good children, to charities, whatever. I don't know if you're going to talk about anything like that, but it's a sad commentary. And then even once you've got a conservator, a lot of conservators are guilty of misusing the ward's property. One thing that is helpful in the context of a conservatorship, the Georgia Code provides that the ward's powers of attorney, previously executed powers of attorney, are automatically revoked once a conservator has been appointed. And we'll talk in a few minutes about just how much elder financial abuse is perpetrated with powers of attorney. So that's a good thing. And then the outline indicates a number of the other probate court remedies that are available to somebody who's been a victim of elder financial abuse. So what is being done to prevent elder financial abuse? There are numerous federal initiatives that I describe on pages 26 to 28 of the outline. The Elder Justice Act and the Elder Justice Coordinating Council, authorized by the Act, attempt to coordinate the efforts of no fewer than 12 U.S. government departments at the very highest levels. The secretaries of all these departments are on this council, and it is a formidable task, to say the least. In the financial services arena, the Financial Industry Regulatory Authority, FINRA, and the North American Securities Administrators Association are promulgating proposed rules and model legislation to protect vulnerable adults from financial exploitation. But closer to home, what can we do to protect our clients from elder financial abuse? I am increasingly recommending sort of a team approach to my aging clients, a multidisciplinary team of allied professionals, as I call them, that the elder would be assembling as part of our work together and then meeting with periodically. And so this is on page 29 if you're following along. So the team members that I like to see on this multidisciplinary team include the estate planning attorney, of course, which often serves as the quarterback of the team, an elder law attorney, especially for those that are going to have long-term care needs. And David is one of my go-to people on that front. A geriatric care manager. And the older my clients get, the more I see a GCM as an absolutely indispensable member of the team. A life care planner, and Mr. Takis is going to be talking to you about that after my program. An investment advisor, but one that is familiar with what investments are appropriate for elders and which ones aren't. And they're generally lower risk tolerance. A government benefit specialist, people who know the ins and outs of all of the alphabet soup of government benefits that, especially in my special needs planning context, a lot of clients get very confused about that. An accountant, a professional bill payer, take the kids out of it, get a professional bonded person to do bills and keep books. Increasingly an elder mediator, and we'll talk about that a little bit at the very end. And whereas attorneys are not ideally suited to be able to pick up on the indicators of elder financial abuse, many of these other team members, the bookkeepers, the bill payers, are ideally suited to be able to pick up on these markers and to alert the rest of the team before it's too late. So another way to prevent elder financial abuse, as I alluded to, is to recognize just how much of it is effectuated with the powers of attorney that we're drafting for our clients. The general power of attorney has been described as the most effective burglary tool since the crowbar, which I think is a very apt kind of tongue-in-cheek description. And for the first 30 years of my practice, I would generally recommend the use of a power of attorney as the tool for planning for a client's lifetime incapacity, sort of the line of first defense. The easy way out, title to a client's assets remains in their name, and they like that idea. You know, the prospect of having to retitle all their assets in the name of a living trust or another vehicle is a real deal breaker for a lot of young people. And I would have sort of a disability trust on standby in case the power of attorney didn't do the trick. And then if we really needed to activate the living trust, the disability trust, then we would take the time and endure the hassle of retitling assets. So although clients appreciate the simplicity and the privacy of a power of attorney approach to dealing with incapacity, it is the lack of former oversight that actually and easily facilitates elder financial abuse. Powers of attorney, at least the ones that we do in our practice, they're 15 pages, single space, tries to anticipate every conceivable financial transaction that the client might need someone to handle for them. And it includes what we call hot powers, those that are particularly devastating if misused. So the power to make gifts, to sell assets, to change beneficiary designations on non-probate assets, and to create joint accounts that are going to pass outside of the probate process. So ideally, in counseling your clients on the defensive use of these broad powers of attorney, we would sit down with them and go over every single power on this 15-page document and discuss with them the worst case scenario for the illicit use of that power. But I'm here to tell you, for those of us who bill on an hourly basis, our clients are not having that conversation. They do not want to spend the necessary time to go over all of those powers. Some offices I've seen require clients, there's a little line for them to initial and sort of opt in to every single power. And that makes them at least think twice. I don't know about your clients, but sometimes I'm under the impression that my clients don't actually read the documents that I prepare for them. And if you have this opt-in approach where they actually have to initial or check, then at least you get to have a very brief discussion with them about the power that they are granting. One of the things that I've seen is that even if you have a conversation with a client about the possible illicit use of a power of attorney document, clients are in total denial that their children would ever use a power of attorney in that fashion. And about 5 years ago, I had a lovely elderly couple whose oldest child was a Methodist minister. Who better to serve a man of the cloth under a power of attorney? until it became readily apparent that this was in the middle of the recession, times were tough. He had a very small congregation in Pooler, Georgia, which is outside of Savannah, like in the middle of nowhere. And he was using the power of attorney that I drafted for my client to steal from him. Methodist minister. So no child, no person is beyond suspicion since my experience with that. And I'm increasingly suggesting to clients that they appoint co-attorneys, in fact, not just the children starting from oldest to youngest, but co-attorneys, in fact. And that way, at least two people have to conspire to rip off the client, which hopefully is less likely to happen than one doing that. And one of the things that seems obvious to us, but not so much to our clients, is that mere relationship by blood or other affinity does not, in and of itself, make for a good attorney in fact. And how many of you, your clients insist on appointing the children from oldest to youngest? And there are numerous factors that you can ferret out to help your clients understand that if their child is a drug addict or an alcoholic or is super stressed out or suffers with depression or all of the things that increase the possibility that somebody would abuse a power of attorney, ferreting out those kinds of things and helping your client come to a better choice of who to appoint under this very powerful document. So one thing, instead of using a general durable power of attorney as the primary tool to help a client during a period of lifetime incapacity, I have been increasingly recommending the use of a fully funded living trust. And for those of us who were trained as lawyers in Georgia, we don't typically use living trusts to avoid probate. If you have to die, Georgia's a great place to do it. Because the probate process is relatively streamlined, it's inexpensive, and in states where that is not the case, a lot of clients use a fully funded living trust as a will substitute to avoid probate. And now, I mentioned that we have a disability trust sort of on standby. I am now activating those trusts as the primary tool, and not using the power of attorney, at least relying on it quite as much. And the great thing about a fully funded living trust is that title to the client's assets is actually transferred out of their individual name and into the name, ideally, of at least two co-trustees. And typically it's the elder and another trusted either child or professional. And yeah, it's a hassle to have to retitle all these assets, and they grouse about it and complain about it. But we have found that to be a very effective tool in avoiding elder abuse. So the co-trustees serve as kind of the gatekeeper for any ne'er-do-well that would approach the client with a fabulous investment opportunity. The co-trustees have the opportunity to think about it, and there's no knee-jerk reaction. All of these free lunches at Maggiano's that are, sponsored by investment people that are bent on taking our clients' money from them. If their assets are all titled in the name of the trust, then the closer after that lunch isn't in a position to be as successful. Another benefit that I'm finding with these revocable living trusts is we get to describe in detail how our clients want to be cared for. Many of my aging clients are bound and determined to age in place at home, with private caregivers, and they don't want to go to assisted living. And as long as it's safe, medically safe for them to stay home, they want their assets to be used for them. And it's an expensive proposition, and of course, the children, the adult children, are usually seriously hacked off at their inheritance being used to keep mom and dad at home with private caregivers. And so we are increasingly drafting in our living trust for our clients provisions that require the trustee to go out and get a life care plan, a care plan that is prepared by an arm's length third-party professional, not the children who stand to inherit what's left, and to implement that plan using the assets of the trust. And many of the, not many, but some, increasingly, geriatric care managers are also willing to serve as healthcare agents under our clients' healthcare directives. And so if you have a third party, GCM, serving as the healthcare agent, she will then make the decisions on healthcare choices that are outlined in the life care plan, and the trustees then are directed to fund the decisions that the arm's length third party has made for our clients. And more of our clients are asking for this. And I don't know if those of you who have GCMs in your firm, if they are willing to do that. But that we're finding that to be a huge help, where the adult children just aren't thinking straight because their inheritance is at risk of being dissipated. So needless to say, the success of using the funded living trust, again, depends on the choice of trustee. And I am a huge fan of professional trustees. And of course, many professional trustees have a very high minimum, so a lot of our clients are not in a position to use the services of professional trustees. But more and more trust companies are offering specific services, elder services, special care services that are tailored to the needs of our aging clients, as well as the special needs issues that my clients deal with. And in the case of the Methodist minister that was using the power of attorney I drafted to steal from his father, we actually retained one of these professional trustees that has an elder care department and specialty. We retitled all the client's assets in the disability trust that was sort of waiting on standby for a day just like this one. And the professional trustee has been successfully managing the client's assets for his benefit ever since. So sadly, there are some professional trustees who recognize a hopelessly dysfunctional family when they see it. And I actually had a professional trustee bail out of one of my more dysfunctional client families and say, no amount of compensation is worth dealing with these people. And yeah, so professional trustee isn't always the final option. One tool that is increasingly being used in this elder financial abuse area is that of elder mediation. How many of you have used elder mediation in your practice? Couple. There aren't that many elder mediators out there, which is... So,
we actually have one here.
Oh. Yay. Okay, we can talk afterwards then. Mary Radford, Professor Mary Radford, who's going to be speaking with you later today, back in 2002 was way ahead of the curve on this one. She did a wonderful article in the Stetson Law Review that's cited on page 46 of your materials. And she made a wonderful case for using elder mediation in the context of guardianships and conservatorships. And oftentimes, the elder mediator can prevent this escalation of, emotion and drama in dysfunctional families that so often can lead to elder financial abuse. And mediation affords a faster resolution than going to court, and it's also more private than having to duke it out in court. And issues that might be appropriate for elder mediation could include less restrictive alternatives to a guardianship or a conservatorship, such as the funded living trust or a power of attorney. Identifying the appropriate parties to serve in these fiduciary capacities as trustee under a living trust or as attorney in fact under a power of attorney. Resolving disagreements between co-trustees or co-attorney in fact, where you got to have unanimous consent or nothing happens. Identifying which allied professionals will serve on the elders team that we talked about. Another one is assessing the financial implications of residential and care options for the elder. Aging in place at home versus the high-end continuing care retirement communities, or, of course, assisted living or nursing home. And increasingly, an issue that is the subject of elder mediation is addressing the elders' inappropriate spending habits on such things as gambling, the shopping networks on TV that are on all night long, call girl and escort services for our elders, and the 1-900 porn numbers. This is the stuff that our elders are entertaining themselves with these days. And another actually new tool that is being used to help elders who are vulnerable in these areas is the TrueLink Visa debit card. How many of you have heard of that or are using that? Almost all of the professional trustees that I work with in the special needs space use the TrueLink debit card for beneficiaries of special needs trust. So in an elder context, the great thing about this TrueLink card is the trustee or the family member that wants the elder to have access to this. You go online and you can literally program the card according to the needs and the vulnerabilities of the elder. So you can program it so that it will allow purchases at sort of regular, legitimate merchants that the elder frequents. You can program it so that purchases are blocked at specific merchants or types of merchants. So if your elder has a drinking problem, you would program it so that it's not able to purchase alcohol. Or casinos. I've actually had 2 clients, families of clients, call and say that their elder mother, in both cases, had tapped out the home equity line on their house gambling in Las Vegas because it was so much fun. And so you can help trim back that kind of inappropriate spending, by blocking casino purchases. You can set pre-approved spending limits that would actually, or cash withdrawal limits that the card could be used for. You can block those international wire transfers, the grandparent scam. Had a client admit this to me. They call in the middle of the night when your client is still kind of groggy and, sleepy, and their grandchild says, "Grandma, you need to wire transfer money to me immediately, but don't tell anybody because I don't want mom and dad, I'm embarrassed." And, if she has the TrueLink debit card, you can block that sort of transfer. So that is, many, many tools we have to use for our clients to protect them. One thing that I wanted to close with today You've probably heard that Brooke Astor, of course, was one of the highest profile victims of elder financial abuse. And I'm going to read for you an excerpt from an article that was written by her grandson, Philip Marshall, that was reprinted in a recent issue of Bifocal, which is the journal of the ABA's Commission on Law and Aging. And it goes like this. To be complacent about elder justice is to be complicit in elder abuse. In fact, our national negligence is a proximate cause of elder abuse. When our elders lose their sight, it's natural. When we turn a blind eye to their plight, it's negligent. When our elders lose their hearing, it's natural. When we are deaf to their cries for help, it's negligent. When our elders lose their voice, it's natural. When we choose not to voice our concerns, it's negligent. And when our elders' capacity is reduced, it's natural. When their physical and financial assets are reduced without their consent, it's criminal. So those are my comments. Thank you for listening. I hope you find the written materials to be helpful.
We may have some questions. We still have a few minutes. I have an observation and a question. First, I would observe that the fraud units on a lot of credit cards are getting better. Personally, I tried to purchase cookies for the bailiffs up in Ringgold. I like to be nice to them. And I went to a bakery called the Sugar Chick. And they turned off my credit card until I called in the fraud unit. My question, though, and then we can let other people ask questions. You mentioned this, and I'm asking because it sounds like you're drafting around this. If you ask a GCM to serve as the healthcare decision maker, what language are you putting in the document to prevent that GCM from becoming paternalistic? I'm aware of a case where a GCM is making many of the decisions, and the decisions that are being made are not the elders' wishes. The GCM is doing what our speakers yesterday were warning against, where a healthcare provider might say, that's stupid, you should do it my way. How do we prevent that from happening?
I do not have a snappy answer for that, and many times the lawyers are not consulted on sort of the in-the-weeds decisions like that. But driving back from the speakers' dinner last night, there's a very heated discussion in the car. Vicki Kind, who spoke to the group yesterday, was very impassioned about that very topic. And I think there's a disconnect between sort of the lawyers up in our ivory tower in the office and what actually happens in the trenches with our clients. And, you know, we can only go so far with what we're doing. And I think it's another nod to the team approach that needs to be followed. And so in addition to having the GCM, we need to have a biomedical ethicist, like Vicki. And I had never heard of that until this program. And, just raising the issues is helpful, because these are issues that, like I said, we don't usually get involved in from a drafting perspective.
Two things. One is, I had one case where a county, it was the son living with mom. He had authority to use her credit card. Unfortunately, he had $650 a day at Sugar Britches, which was not a bakery. And he had spent over 6 months about $150,000 of mom's money, of which she only had about $300,000. The only way the other sister found out about it, who lived away, was when the neighbor called sister and said, Mom's out in the yard, can't get in, it's cold, and we don't know where your brother is. He was in Vegas with the girl he met at Sugar Britches. And anyway, long story short, sister gets involved, finds out that brothers, we thought we had plenty of money to put mom in the assisted living. Didn't, because he had taken most of it, but we got her in and we filed for guardianship and conservatorship at that point. We had all the credit cards showing all this. And you know what the police told us? Well, Mom gave him authorized use on the credit card. There's nothing we can do about it. I mean, I had him on the stand saying, well, Mom said I could use a credit card. Did she say you could use it at Victoria's Secret, the tanning bed, the nail salon, and Sugar Britches? Well, no, but they wouldn't do anything. So that was one very frustrating thing. They were like, too bad.
Well, and again, it's probably the size of I mean, that was a big loss for her.
Right.
But in the grand scheme of things.
And that's most of my clients, which brings me to my next issue. I love the team approach. Most of my clients can't afford a team. They're lucky they can afford a power of attorney and a will. They're not people who have substantial wealth, but what they have, they want to protect. And so I used to be only one power of attorney because there's too many, chiefs and not enough Indians in the issue. But now I agree with you on I'm going more towards the co-powers of attorney because at least they're oversight on each other. And so it's less likely that there's going to be abuse when there's a little money, but not that much money, or co-trustees on a trust. But it is for the people who don't have tons of money and they can't every client wants to age in. I have very few who don't want to age in place, but the fact of the matter is 24/7 caregivers are too expensive for 98% of my clients, so that's not a choice. More educating the fiduciary, whoever that is, on this is mom or dad's money, it's not your money, and we're going to keep the best for them. Sometimes I make them sign something, an agreement on that, just something. And I try to bring the whole family into it, although we might only have one who is the actual fiduciary. But sometimes I'm like, well, and my belief is you have nothing to hide, you hide nothing. And I tell the family that. So I'm like, because sometimes the power of attorney gets well, Mom made me the power of attorney. I'm not showing you the bank accounts and whatnot. Makes everybody else very suspicious. So we'll make it an agreement that you're the power of attorney, but every month you'll let everybody else see the bank accounts and what's spending the money on, or do an accounting to everybody else in the family. Those are just ways for people who don't have a lot of money to be protected from a bad kid.
Misuse. So in your materials, there are actually suggestions just like that, what you can include in your power of attorney, or in the living trust for that matter, as far as accountability to the other sort of heirs apparent or other trusted fiduciaries in the client's life. And it calls for some customized drafting that your typical boilerplate power of attorney document doesn't have in it. A word about the expense of the team. It is more expensive than just having an estate planning attorney, but when you look at the value of the estate that can be preserved by a little more upfront expense, lining up this team of allied professionals, many times you will save multiples of what the cost is to have the team of allied professionals. Preserving hundreds of thousands of dollars. But I know it's a tough sell for clients, and especially for those of us who have to bill on an hourly basis. They're frantic about clock ticking, and they don't want to talk about this stuff if we're going to get billed for it. So, any other questions? Yeah.
Along those lines, I work in a hospital, and I've seen the movement at the hospitals to go to a third party who makes the health decisions, and it is a disaster. Most of our patients are very upset that they lose their autonomy to make their own decisions, or even family members are saying, my mom was being treated by this primary care provider, and now you're substituting this other person who's going to make all these decisions. supposedly, in theory, it sounded really great that this person could oversee everything and get care here and do medications here, but it doesn't necessarily work well. So if you're going to take a team approach, what would you say? If someone can't afford all of those people that you listed, what are your top 3?
Well, again, I think the geriatric care manager is worth her weight in gold. And, just like not all lawyers are good, it doesn't surprise me to hear that not all GCMs are good. The basic notion behind a healthcare directive is that as long as the elder can make her own healthcare decisions, the authority under the document doesn't give the GCM or the healthcare agent the ability to override that. And so something's wrong with a client that is capable of making her own healthcare decisions, and a GCM or an adult child or anybody else is being allowed to run roughshod over the client's wishes. Now, yesterday's conference, I guess, was all about incapacity, and Mary Radford will be talking to you about incapacity today, and that's that sort of gray area where does mom really know? Can she really knowingly consent and meaningfully consent? But I'm here to tell you that lawyers are not the ones that should be advising families on these medical issues. It's not our bailiwick. This is just not what clients should be turning to us to do. And, if there's anything, to David's point, that we can include in our drafting that has been informed by people who actually do know what they're doing in this area, I sure would love to know about it.
Last question.
Is TrueLink a separate company, or is it something that's offered by most banks, is there a competitor or similar service?
TrueLink Financial, if you just type in, when I tried to find TrueLink Financial, I just typed in TrueLink, and there's a whole line of tennis shoes produced by TrueLink. That's not where you want to be. So it's TrueLink Financial, and it is a separate independent for-profit company. And the debit card says Visa on it, but it is a debit card that is programmed the way we talked about. The reason that it works in the special needs trust arena is because you can limit the amount that is accessible on the card so it doesn't violate the SSI rules. And you can also program it so that it can't be used to buy food and shelter expenses, which is another issue for SSI. But just about every professional trustee that I work with has an account. It's $10 a month. I mean, it's very inexpensive to get a TrueLink card. And so I don't know of any other competitor, and the Special Needs Alliance has had a lot of back and forth with the TrueLink people and the Social Security Administration, coming up with manuals and other guidance that has resulted in SSA basically accepting this in the context of people that are on means-tested benefits. So I sort of wish I could get one for my daughter, who's a young lady in New York City now, and I'm still helping to defray her expenses. And when I see some of the places she's spending money at, I really would love to have had a TrueLink card for her. So anyway, thank you for listening. I hope it was helpful.